Reception is a fundamental concept for understanding Australian law. When each Australian colony was granted self-government, rather than starting with a blank page, each colony received so much of English common and statute law as was applicable to the new colony's circumstances. In South Australia, reception occurred on 28 December 1836. English law capable of being applied in South Australia became South Australian law on that date, including a rule that a landowner was not liable to travellers if the landowner's animals escaped from their fields and strayed onto the highway, causing harm. This was still the law in 1979 when sheep from the Kerrins farm strayed onto the road. Christine Rook's car struck two of the sheep. While swerving to avoid them, she collided with the Trigwell's car. Sadly, she died in the accident. The Trigwells sued her insurer, who sued the farmers. The court considered whether this ancient common law, first noted around 1700, could possibly still be valid in modern times of fast-moving cars and high traffic. Justice Gibbs noted that there was no reason why the law would not have been applicable to the conditions in South Australia in 1836, and said once the law becomes part of the law of the territory, it remains so until it is repealed or amended by legislation. Justice Mason recognised that the world had changed very much since the common law rule was established, but the court was not the institution to sort that out. He said, if it should emerge that a specific common law rule was based on the existence of particular conditions or circumstances, whether social or economic, and that they have undergone a radical change, then in a simple or clear case, the court may be justified in moulding the rule to meet the new conditions and circumstances. But there are very powerful reasons why the court should be reluctant to engage in such an exercise. The court is neither a legislature nor a law reform agency. Its responsibility is to decide cases by applying the law to the facts as found. As a result of this ancient rule, the farmers were not liable for their sheep being on the road. From this case, we learn that the laws of England were received by each new colony in Australia, and that the courts strongly prefer that legal innovations should come from the elected Parliament.